Good afternoon, everyone. Hope everyone's well this afternoon. Good afternoon, Ms. Bridgewater.
Hello, Judge.
Good afternoon, Your Honor.
Good afternoon, Ms. Fall.
Good
When is the Ms. Bridgewater? When is the SAP reset date?
October the 4th.
Okay, thank you. October 4th.
Mhm.
And where are we going to begin this afternoon?
Good afternoon, Your Honor.
Good afternoon, Officer Milton. Good to see you.
Good to see you too, sir. How's everybody? Before you is Ms. McClendon, position number 8.
Good afternoon, Ms. McClendon. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 006347C with simple assault, family violence. Good afternoon, Mr. Howard. Is there a history?
Third arrest, 2011 shoplifting dismissed, and 1998 shoplifting first offense.
Okay, thank you. Who's presenting for the state?
It's my case, Your Honor. One moment.
Okay, good afternoon, Ms. Duncan.
Good afternoon. If my computer will work correctly, I'll be able to present for you today. 1 second. Ms. McClendon?
Yes, ma'am.
Okay. This incident occurred yesterday at 2698 220 Lake Circle in South Fulton. In this case,
It's 2964.
Ms. McClendon, please remain silent. The state is just presenting the case before the judge.
in this case, the defendant is charged with simple assault, family violence. The warrant indicates that in this instance, the defendant pulled out a firearm during a dispute with the victim in this case. The victim in this case is Antonio Norcutt. Antonio is ANTONIO, Northcutt, NORTHCUTT. As of right now, Your Honor, those are all of the facts that we have, but as the court knows, this is a open and pending case and further investigation has commenced. However, we do have a concern about the risk of reoffense, given that they had some type of relationship in the past. We were able to make contact with Mr. Norcutt. He did state that they no longer live together and are no longer in a relationship, and that he wants no contact because they share no children. And he said to our victim advocate today that this is not the first time that she's been violent towards him. He stated that during their argument, she pulled out a gun and was waving it around. He stated that in the past, he's never called the police. However, he has left the residence with her, has no plans to return, wants no contact. He indicated to our victim advocate that he would be on Zoom if Your Honor would like to sound for him.
I see him there, Ms. Duncan, so I'll get to him if he'd like to speak, okay?
Okay, given the facts, 1 second. The state will be asking for a $5,000 surety, given the fact that there is a firearm involved. The state understands that the defendant does have limited criminal history, but to pull out a gun and wave it around during an altercation with someone is extremely reckless. I don't think I have to inform the court what types of things could have happened had that firearm been discharged. We're asking for no further contact. Stay away from, she doesn't have to stay away. My apologies. We've updated in the fact that he no longer lives there. 1 day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
Thank you. Good afternoon, Ms. Gann.
Good afternoon, Your Honor, and my apologies to you, Ms. Duncan, for the interruption. Ms. Janina McClendon is 44 years old. She has been in the Atlanta, Georgia area her entire life. She is the proud mother of 4 children, ages 25, 18, 16, and 19. She is not receiving any child support for the minor children. Your Honor, Ms. McClendon completed the 11th grade. She went on to obtain a GED. At the moment, she is unemployed. Prior to She has some history as a bus driver, but she's not doing that anymore. My client strongly denies the allegations, Your Honor. She stated that she was in fear of her life and that the complaining witness, Mr. Norcutt, had pushed and hit her. My client does not have any prior convictions whatsoever for any violence. Therefore, I am requesting a signature bond and she is recommended. If Your Honor determines that she is ineligible, I would ask for a bond of no more than $1,000, and we are unopposed to no contact. Thank you, Your Honor.
Mr. Northcutt, I see you there. If you would like to address the court, you don't have to address the court, but if you would like to address the court, now is your opportunity. I need to for you to unmute and you need to raise your right hand and I'll have to swear you in, okay? Do you swear to affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, I do.
Okay, what would you like to tell? You can put your hand down, Mr. Northcutt. What would you like to tell the court?
I like to clear for the record that I never pushed or anything, and the police did come and ask the children, and the children, agreed with me that I never touched or anything. And I have video of everything that she have done from the time I walked in the house to try to get my clothes to leave, and she didn't want me to leave. Then she wanted to grab on me and all that, then she tried to take my keys from me. We do have a truck together, that she loaned me the money to buy the truck with, which I did agree to pay her back. So I do want to pay her back her money, but I don't want her to be trying to fool my accounts and stuff while I'm on the road because of some fact she have access to it. But from my understanding, I can go on to the Secretary of State and change her name off of it because I am the registered owner and I just made her organize. And her family and all that already threatened me and all that, so I just don't want no contact with her. That's it.
Okay, so Mr. Northcutt, you don't live at that address, is that correct?
No, sir.
Okay, all right. So this is a bond hearing. As far as everything that has to do with the truck, you'll have to deal with that on your own. You're not going to be able to have any contact with Ms. McClendon. So you're going to have to arrange a third party to deal with to get her the money for that truck if that's what you're seeking to do. Okay.
Okay. Yes.
All right. Anything further, Mr. Northcutt?
No, sir. That'll be it.
Okay. As such, it's going to be a $5,000 signature bond through pretrial one-day anger awareness. No further contact with Mr. Northcutt, and no drugs, alcohol, or weapons while out on bond. Ms. McClendon, I just want to make it clear what no contact means. It means no telephone contact, no personal contact, no Facebook contact, no social media contact, no contact whatsoever. Do you understand that, ma'am? Okay, thank you. Good luck to you, Ms. McClendon. You also, Mr. Northcutt.
Thank you, Your Honor. And Your Honor, I will need a breakout for position 9.
Okay, thank you for letting me know that.
You're welcome.
Who do we have next?
Position 14, Ms. Shaw.
Good afternoon, Ms. Shaw. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank
I
you.
can leave myself.
Yes, Mr. Northcutt, you can go if you please.
Okay.
Ms. Shaw, you've been charged in case 22 CR 006353G with battery family violence. Is there a history, Mr. Howard?
4th arrest. Last was 2020 trespass. It was dismissed after PTR. Got a 2016. She was in the Army. I guess she was cited for wrongful use of a controlled substance. 2017 wrongful use of marijuana. That's all.
All right. Good afternoon, Mr. Dudley.
Good afternoon, Your Honor. This incident took place on September 17th, 2022 at 1803 Crest Ridge Drive. The defendant and the victim, Precious Daniels, were in a verbal dispute about driving to a wedding. Ms. Daniels decided to drive herself since the defendant would not drive her. Ms. Daniels grabbed her keys and headed upstairs, at which point the defendant then tried to grab her keys to prevent Ms. Daniels from leaving the residence. The defendant grabbed the keys as she was standing behind Ms. Daniels. And so Ms. Daniels then pushed the defendant back against the wall as she tried to pull the keys back away from the defendant. The defendant then grabbed her around her neck and scratched her from her throat to the back towards her ear. And officers did observe a substantial scratch marks around Ms. Daniels' neck. The two have lived together for 2 years. Our victim advocate was able to get in contact with the victim, and the victim let us know that they are in a relationship and they do currently live together. The victim did state that nothing of the sort has happened before, but the disagreement did turn physical between them. The victim also stated that she will be on the Zoom today if we can sound for her after this. And if you give me 1 second, I'll give you the state's recommendation for bond. You're going to recommend a $3,000 surety bond, a stay away from the incident location, no further contact with the victim, and no drugs, alcohols, or weapon while out on bond. Nothing further from the state.
Thank you. Mr. Farset, is this your case?
Yes, Judge, and actually, I'm a friend of the family, and I'm also obviously an attorney as well. I've known her father for pretty much all my life, so, and I'm familiar with Ms. Shaw. I will say that Ms. Shaw is 29 years of age. She is a employee at Amazon. She's also an honorably discharged veteran. That's correct, as the state has mentioned, she was in a relationship with Ms. Daniels, who is on the call. She's written out a statement where she indicates that she did not actually contact law enforcement. I believe it was a neighbor that contacted law enforcement. She does state that this incident got out of hand, and actually places some of the blame on herself as well, that they were both engaged in an argument that became physical, and they both share some of the blame in that. I know we're not here to address prosecution today, but she does not want to go forward with charges. They do plan on continuing to be in a relationship. As she stated to the victim's advocate, nothing like this has happened before. I'm asking the court to give her a signature bond, $1,000 signature bond. No violent contact, I think, would be appropriate. They do plan on living together. They were in the process of moving from one location to another. Based on my discussions with Ms. Daniels, her father is on the call. You see him, he's Mary Jean's computer, Mr. Charles Davis. He's on the call as well. I don't believe that Your Honor is going to see any further trouble from Ms. Daniels or Ms. Shaw in this case. That's if the court grant my request.
Okay, thank you. Ms. Daniels, if you don't have to address the court, but if you want to wish to address the court, now is your opportunity. If you are on the call, I'll need for you to activate your camera, unmute yourself, and I'll have to swear you in if you wish to participate.
Okay. Can you hear me?
Yes, you're under, Ms. Daniels, are you under pressures? Is that?
Yes, that's me.
Okay, yes. Can you raise your right hand for me?
Yes.
Do you swear from the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down. What would you like to tell the court?
This was just an incident that occurred. Like he said, nothing has happened like this before. I can promise you it won't happen again due to the situation. I don't like seeing her in that predicament, and she don't like seeing me, and I would never want to see her in that predicament again. But we both play a role in it. I can say that. And yeah, I wouldn't want to press any charges or anything on her. Like you said, she's a good person. I'm a good person. We just had this one verbal confrontation and everything. But I can assure you that it won't happen again. Yeah.
And you're not afraid of her, ma'am?
No.
Okay.
Yeah.
All right. Anything further, Ms. Daniels?
No, sir.
Okay. It's going to be a $3,000 signature bond through pretrial, 1-day anger awareness, no further violent contact with Ms. Daniels, and no drugs, alcohol, or weapons while out on bond. So I'm going to give you the opportunity to get out, Ms. Shaw, and come back at another time to fight these charges. But you're going to have to make sure that you show up for all court dates and that you don't violate this bond order anyway. Okay, ma'am?
Yes, sir.
Okay, very good. Anything further on Ms. Shaw this afternoon?
Yes, Your Honor, the state would just like to put on record its objection for the no further violent contact, as we recommend, given the not sufficient cooling off period, that it be no further contact.
Okay. It's my understanding that the offense date is September 17th. Today is the 20th. I believe that Ms. Shaw has been in custody for at least 2 days. As such, I do believe that there's been sufficient cooling off period in this matter. Good luck to you, Ms. Shaw and Ms. Daniels.
That's all I have, Judge.
Yes, Mr. Fawcett also.
Thank you, Your Honor. May we be excused?
Yes, have a good afternoon. We'll see you next time. Thank you.
Thank
Who do we have next?
Wait on Miss Gantz. This is Miss Carolyn Jackson. I'm not sure her position number.
Carolyn Jackson. Is Ms. Gant?
There she is.
Is this your client? Do you need to
Yes,
speak
Your
with
Honor,
her?
position 6.
Okay. Do you need to speak with her before?
I've completed my interview with Ms.
Okay.
Jackson.
All right, very good. Good afternoon, Ms. Jackson. I'm Judge
Good
Eric.
afternoon. How are you doing?
I'm doing well, Ms. Jackson. Thank you. This is the state court expedited accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. You have been charged in case 22 CR 006312G with battery. Is there a history, Mr. Howard?
This was the reset from yesterday.
I don't know that.
Yes, reset yesterday.
Okay.
Third arrest. But actually, yeah, third. Last arrest was May 17th, City of South Fulton for trespass. It's a May 6th, City of South Fulton trespass. That's all I have.
Mr. Dudley?
Yes, Your Honor, this incident took place on September 18th of 2022 at Savannah Suites Hotel at 3480 Welcome Mall Road Southwest. The defendant and the victim, Kimbara, KHEMBARA White, were in a dispute over him not wanting to leave her hotel room. Once Mr. White refused to leave the defendant's hotel room, she became very irate and began throwing things around the hotel room. The defendant picked up an aerosol can and began to spray Mr. White in the face. After spraying Mr. White in the face with the aerosol spray, she then began hitting Mr. White in the face and arm, causing multiple lacerations to Mr. White's forearm. The state is going to recommend a $3,000 surety bond, no further contact with the victim, stay away from the incident location, and no alcohol, drugs, or weapons while out on bond.
Thank you, Ms. Gant.
Thank you, Your Honor. Ms. Carolyn Jackson is 32 years old. She has been in the Atlanta, Georgia area for about 17 years. She is the proud mother of 2 children, ages 13 and 5. Your Honor, we are opposed to the stay away at the incident location. Ms. Jackson informs me that she has been residing at this residence for about 3 weeks and her room is currently paid up in full. She recently lost her apartment. Her minor children are in the care of her father. She is trying to get back on her feet. She does not know Mr. White. She does not want any contact with him, and it is unknown whether or not he's at the hotel, but he is not an occupant in her hotel room at that extended stay, Your Honor. Ms. Jackson completed high school. She also has 2 years of college. She studied criminal justice and law at Miles College in Alabama. She is currently employed at Cleveland Wheels and Tires. She has been in this position for about 6 months, and she strongly denies the allegations, as we heard from the state. And we are in agreement that Mr. White refused to leave her room. Ms. Jackson maintains that she was acting in self-defense. This person was in her room. She stated that she sought the assistance of security and the front desk staff. He refused to leave her room. He lunged at her. She reached out to grab his arms to stop him from hurting her. And of course, in snatching away, her nail scratched his arm, and she denies spraying him with anything, Your Honor. Now, I do acknowledge that my client has open cases. She's presumed innocent in those cases as well as this one. She does not have any convictions for violence. Therefore, I am recommending or requesting a signature bond as she is recommended. And again, we are opposed to the stay away. However, we are unopposed to the no contact order. Thank you, Your Honor.
Okay, it's going to be a $5,000 signature bond through the jail. No further contact with Mr. White, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. Jackson.
Thank you so much, sir.
You're
Thank
welcome.
you, Your Honor.
Who do we have next?
Good afternoon, Judge Morrow. Good to see you.
Good afternoon. Always a pleasure. Thank you.
This is going to be position 2, Mr. Bailey, and we also have the mother who would like to speak when it's her turn.
Okay. Is the mother in the courtroom with you?
Yes, she's in the gallery.
Okay, thank you. Good afternoon, Ms. Bailey. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 006349C with criminal trespass. Is there a history, Mr. Howard?
No.
Ms. Falk, good afternoon.
Good afternoon, Your Honor. How are you?
I'm doing well, thank you.
State's recommendation is a $2,000 signature bond through pretrial services, 1-day anger awareness, a curfew of 6 a.m. to 6 p.m., no alcohol, drugs, or weapons, and we have no further violent contact with Antoinelle Bailey. That is ANTIONELLE Bailey, BAILEY. As far as the stay away order, I would like to hear from Miss Bailey, who is the victim in this case. Essentially, what happened is on September 19th, 2022 at 2352 Larkwood Road, Atlanta, Miss Bailey reported that the defendant, her son, who is just turned 17 about 2 weeks ago, came back to her home after school and was trying to come into the house. The defendant then ripped the Xfinity camera off the door. And when asked, the defendant admitted he ripped the camera off the door and threw it into the woods and broke it. The officers were able to locate it, and Miss Bailey did state she wanted to press charges. So the reason the state is asking about the stay away is because we're unclear from the warrant whether he lived there or was just going into his mother's house after school. And so I feel like Miss Bailey can give us a little bit of clarity there, but the state's recommending a pretrial services bond.
Okay, thank you, Ms. Falk. Ms. McLeod, I
Yes,
take
Your
that you don't disagree with a signature bond through pretrial, and
I do not, Your Honor, and I tried to call Mom, but I was unable to get her because I needed to know whether or not he does live there, Your Honor. He tells me his name is on police. He is a 10th grader, 10th, 11th grade classes he's doing now. And he was coming from school. He does live with Mom. So I really wanted to contact Mom to find out her feelings as well. So if she's here, then perhaps she can tell us how she feels. He doesn't have anywhere else to go, Your Honor. I just wanted to put that out there.
all right, I understand. Can we hear from Ms. Bailey? Let's see. Good afternoon, Ms. Bailey. Can you raise your right hand for me?
Yes.
Do you swear or affirm the testimony you're about to give before this court to be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down, ma'am. Thank you. What would you like to tell the court about Davion?
Actually, in order for him to come back home to the household, he would have to be going to school, no drugs, he would be having a drug test on a regular basis, and to be checking in on him as well, because if I tell him to clean up or do anything, it's always word for word, bucking at me, coming at me, or talking to me any kind of way, and I should not have that type of feel going on into my household.
So he's been living with you
Yes.
continuously,
Yes.
and he is in school?
Yes, and sometimes he doesn't want to go to school. Sometimes when he go to school, they have to call me periodically, let me know that he has took something at the school, as well as on some type of pill or some type of drug, or he's leaving from school.
Okay. And so you're willing to sign for him?
It's only if I have that stipulation.
Say it again, ma'am?
Only if I have that strict stipulation of going to school, obeying, and drug test, and it's for the anger, because it can get to the point that one of us can end up being hurt. And I have every right to defend in my house and come to him at 17 years old, looking at me. And I am the parent, and I am the one to take care of him, and I'm a single parent, and I am the one to take care of him.
Does he have anywhere else to go aside?
No, he does not.
Besides your house?
His father does not even want to deal with him.
Okay, all right, thank you, ma'am. Ms. McLeod, Ms. Falk?
Your Honor, well, it sounds like Mom is asking that he has some court restrictions on him, that he attends school, finishes the school and so on, and goes regularly. and has a curfew. And I would think, given his age, that would be appropriate, and we would definitely not be opposed to that.
Okay. Thank you, Ms. Falk.
The only thing I have to say about this is obviously we're not in juvenile court anymore. So I think Mr. Bailey needs to be aware of that. A lot of the things it sounds like Miss Bailey is asking for is stuff that would normally be applied to a juvenile in juvenile court. Unfortunately, at this point, Mr. Bailey is 17 years old, so he's now dealing with adult court. I think we can order random drug screens. I don't think we can order he obey her. I don't think that legally I can ask for that. I think the no further violent contact we have asked for, and we can order that he attend school, I believe.
Yes.
But it kind of sounds as though, Your Honor, just quite frankly, this sounds like the only person who still wants to have, I guess, involvement with him and have him stay at her house. And so she's kind of setting the terms of what she will accept and will not accept to sign off on this bond and to co-sign on the bond, and he would need a co-signer.
Great. What is the address of the home address, please?
The address we have is 2352 Larkwood, Larchwood Road in Atlanta, Georgia.
Mr. Bailey, you have heard all that. This is your mother trying to do the best that she can by you, but you're going to have to, start changing your ways. Okay, this is not going to keep happening, because I don't want to see you go down the road that you're going down. You're only 17 years old. Okay, so I'm going to order that. I'm going to give you the $2,000 signature bond through pretrial that your mother's going to have through pretrial, and it's going to be per the judge, per me. So I'm sending you through pretrial myself. If you do not show up for pretrial when you're supposed to, or we contact them when you're supposed to, then this bond's going to be withdrawn. If you are to stay at 2352 Larkwood Road, and I believe that's your mother's address, you're to stay at your mother's address. If you are put out of your mother's address for any reason, then this bond is going to be revoked. So if you're not living with her, you're not going to be out, which means that you're going to have to, follow some guidelines. One of those guidelines is that you're going to stay in school. You're going to go to school when you're supposed to go, and you're going to stay for as long as you're supposed to stay. You're also going to have a curfew. Your curfew is going to be from 6 a.m. until 9 p.m. So you cannot go out after 9 p.m. All right. You're also going to.
Whoa. What's the curfew again?
6 a.m. to 9 p.m.
9 p.m.
I think Your Honor might mean 9 p.m. to 6 a.m.
6 a.m.
Right. You got to be in by 9 p.m. and you can't go out again until 6 a.m. Okay. You're going to have random drug screens. If any of these screens come back positive, then this bond's going to be revoked, and you're going to be right back where you are. You're also going to have random alcohol screens. You shouldn't be having any alcohol, given that you're not of age. And there will be no drugs, alcohol, obviously, or weapons while you're out on bond. So what all this means, Mr. Bailey, is that I'm giving you the opportunity to do the right thing. If you don't do the right thing, especially the right thing by your mother, then you're going to be sitting right back where you are, and you're going to be sitting in there until this case, until you either make bond through somebody, which will be a $2,000 bond, or you're going to stay in custody until a plea or your trial. All right. Any questions, Ms. McLeod, Ms. Falk?
What's the mother?
No, Your Honor.
Mother's name is, I believe, is Antionelle. Is that correct, Ms. Falk?
Yes, Your Honor.
Yes.
Okay. And Mr. Howard, I'm going to waive that utility bill since she's already in court. So if you'll send me that paperwork, I'll get it signed and back to you.
What's the last name?
Bailey.
Same letter.
Same as the, all right. You understand me, Mr. Bailey?
Yes, sir.
All right. You have any questions?
No, sir.
All right. Good luck to you, sir. Do right by your mother. You hear me?
Yes, sir. I got you.
All right.
Francois, can you send mother to the pretrial trailer, please?
Okay, glad you got it.
Thank you.
All right, you got it. Yeah, it's, Position 4, Genlac.
Good afternoon, Mr. Jack. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. Can you raise your right hand for me? Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. You have been charged in case 22 CR 006360G with battery family violence. Is there a history?
Hold on. Judge, who we on? I had to call the pretrial trailer, let her know she was coming.
It appears that
4,
Number 4,
position 4.
second arrest. Last was 2019 out of New Jersey for shoplifting. That was a conviction. That's all I have.
Thank you. Ms. Duncan?
Yes, Your Honor, this incident did occur yesterday at 1991 DeLoe Drive Southwest. In this incident, Your Honor, the state has a concern about intimidation of the witness, given that we were able to contact the victim in this case and they stated that they don't want to prosecute. However, we have a concern about intimidation, given that in this case, the defendant is accused of having thrown a phone at the victim in this case, as well as attacked him by scratching on the neck, leaving visible marks all over the neck. Stated that they've been in a relationship for 2 years and that they do live together. The state is going to be asking, given the violence alleged and the visible injuries, for a $2,500 surety, no further contact to stay away from the incident location, 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
Can you give me the name of the alleged victim, Ms. Duncan?
My apologies. That is Kari Orange Blakeney, and that's Kharie. Last name Orange, common spelling, dash Blakeney, Blakney.
Ms. Gant?
Thank you, Your Honor. Ms. Tanera Genlac is 23 years old. She has been in the Atlanta area since July 2022. She does not have any family in the area, nor does she have any children. Your Honor, we are opposed to the stay away at the incident location. Ms. Genlac informs me that that is her apartment and that Mr. Orange Blakely does not live there, Your Honor. She wants contact with him. However, I was unable to reach him. So we will defer to the court's ruling. And if the court orders her to stay away, we would ask for a one-time law enforcement escort so that she can either confirm that he isn't at the residence or so that she can retrieve her belongings. Now, a little bit more about Ms. Genlac. She completed high school. She is currently enrolled in a sonography program at Starlight Medical. She's recently employed at King of Diamonds. She has been in that position for 1 week. Therefore, she is on probation and likely to lose her job if she does not return soon. I am requesting a signature bond on Ms. Genlac's behalf. She does not have any convictions for violence, Your Honor, and she is recommended. And regarding the allegations, she denies them. She's presumed innocent at this point. She informs me that she was acting in self-defense and that Mr. Orange Blakely, the complaining witness, was pushing and grabbing her neck, and that she has bruises and scratches on her arms and the back of her neck. And of course, in her mugshot, she had a Band-Aid on her head. So in closing, I am requesting a signature bond. And again, we are opposed to the stay away and the no contact orders, Your Honor. Thank you.
If I may, Your Honor, to clarify for the record, the Band-Aid on her head, according to a report that I received, is from an injury that she inflicted on herself in the back of the patrol vehicle. Nothing further.
Mr. Orange Blakeney on the line?
Yes.
Okay, if you'd like to tell the court something, I need for you to raise your right hand. You swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. What would you like to tell the court, Mr. Orange?
I'm okay with me and my girlfriend is fine, and I'm okay with her returning. Like, I'm not pressing charges. Like, I don't want to press charges on her.
Has this happened before?
Like this situation, no, I haven't.
Okay, you're afraid of her?
No, I'm not. I love her. She's my favorite person I ever been with.
All right. Anything further, sir?
No, that's it. She's
All
a
right.
good.
It's going to be a $3,000 signature bond through pretrial, 1-day anger awareness, no further violent contact with Mr. Orange Blakeney, and no drugs, alcohol, or weapons while out on bond. All right, good luck to you, ma'am.
And the state would just like for the record to object to the signature bond and the battery family violence where injuries are alleged.
Objection noted. Who do we have next?
Thank you, Your Honor.
You're welcome.
Position 10, McMillan. First name Shakia.
Okay, thank you.
You're welcome.
Good afternoon, Ms. McMillan. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Good afternoon, Your Honor. Yes, I do.
Okay, thank you, ma'am. You have been charged in case 22 CR 006355B with criminal trespass, family violence, and simple battery family violence. Is there a history, Mr. Howard?
11 total. Last arrest was 2021, suspended license and window tint. She don't have any violent convictions.
Okay, thank you. Ms. Duncan?
Yes, sir. This incident occurred on January 9th, 2022 at 3378 Greenbrier Parkway Southwest. In this instance, officers were dispatched to the location for a dispute. They encountered the victim in this case, Mr. Rontre Stripling. That's RONTRESTRIPLING. He indicated to officers that the defendant is his ex-girlfriend. She confronted him in his parking lot of his apartment. And during a verbal altercation, she struck him several times in the head and face, as well as damaged his vehicle by slamming her car door into his. Your Honor, in this case, we have a concern about the risk of reoffense. We were able to make contact with the victim in this case, and he stated that they're no longer in a relationship and they no longer live together, but he keeps getting contacted by this defendant and her family members, and we have a concern for the particular safety of this victim. So given the violence alleged and the nature of the incident, as well as the information we received from the victim in this case, he would like no further contact and wants her to stay away from calling him and others involved in his life. Sir, we're going to be requesting a $3,000 total surety bond in this case. That's $500 for the criminal trespass and $2,500 for the simple battery family violence, along with a no further contact, stay away from that incident location, because as I understand it, that is his location. 1-day anger awareness, no alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
Ms. Kim, does she have any reason to be around Mr. Ling?
Nope, Your Honor.
Does she have any reason to go back to the incident location?
Nope, Your Honor.
All right, so it's going to be a $1,000 signature bond through pretrial on each count, which makes it a $2,000 signature bond through pretrial. 1-day anger awareness, no further contact with the alleged victim, stay away from the incident location, and no drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. Kim?
Yes, Your Honor. Thank you.
Let me explain, Deputy Francois, if you can unmute to Ms. McMillan. I'm gonna give you the opportunity to sign yourself out, but you can have no further contact with Mr. Ling. No contact means no contact whatsoever. No personal contact, no telephone contact, no social media contact, no contact whatsoever. If we find that you are in contact with him, this bond will be revoked and you'll be right back where you are. You understand?
Yes, Your Honor.
All right. Good luck to you, ma'am.
Thank you, Mr. Morrow.
You're welcome.
Position 16, Westbrooks.
Good afternoon, Ms. Westbrook. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Okay, you've been charged in case 22 CR 0063548 with theft by shoplifting. Is there a history, Mr. Howard?
Third arrest. Last was August 31st for shoplifting. Before that was February 2021, misdemeanor possession of marijuana conviction. That August arrest is a felony, and that's a pretrial case. That's it.
Okay, thank you, Mr. Dudley.
Yes, Your Honor, this incident took place yesterday at 65 Ponce de Leon Ave Northeast at the TJ Maxx. The defendant entered the TJ Maxx and exited passing each point of sale without paying for several items, valuing around $247.63. As pretrial mentioned, the defendant was arrested recently, earlier this year, for the theft by shoplifting. That was on August 31st of 2022. Here she is again, been arrested for theft by shoplifting. So that gives states a concern of a risk of reoffense. State is going to recommend a $1,000 surety bond, stay away from the incident location, and no drugs, alcohol, or weapons while out on bond. Nothing further from the state.
Thank you, Ms. Kim.
Yes, Your Honor. Ms. Westbrooks is 20 years old, Your Honor, and she had 2 children, and one of them she lost. One died early, and she has been here in Georgia for all her life. She's not married, and the father of the children is actually incarcerated right now, so there's no child support that is coming to take care of a minor child. And she also has no employment. She was not able to get any job for the last 4 months, and she completed up to 10th grade in high school. And we would like to request for a signature on bond, because even $500 surety bond that she has currently, that is no bond to her. She has no money to put down anything. So we would like to request for a signature on bond. Thank you.
All right, so it's going to be $1,000 good bond. Stay away from the TJ Maxx on Ponce de Leon Avenue, and no drugs, alcohol, or weapons while out on bond. Good luck to you, Ms. West.
Position 18, Williams.
Good afternoon, Mr. Williams. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes.
Thank you. You have been charged in case 22 CR 006357E with criminal trespass. Is there a history, Mr. Howard?
13 total. Last arrest was on the 2nd of this month for felony obstruction. That was out of Cherokee County. That's open. It's obstruction and public drunk. A 2019 battery, NOLO. 2019 probation for suspended license. 2013 FTA shoplifting. 2013 burglary, first offender. That's it.
Mr. Dudley?
Yes, Your Honor, this incident took place on August 15th of 2022 at 2890 Jonesboro Road, Southeast. The defendant went to the victim's, Felicia Leslie's, home and started an argument with her about their child that they have together. He started throwing stuff around her apartment, and in the course of that, he shattered one of her vases, after which he left the location. As pretrial mentioned, the defendant has an FTO on his record within the last 10 years, gives the state concerns that he may be a flight risk. The state is going to recommend a $1,000 surety bond, no further contact with the victim, a stay away from the incident location, and no alcohol, drugs, or weapons while out on bond. Nothing further from the state.
Ms. Kim?
Yes, Your Honor. Mr. Williams is 36 years old, and he was born and raised here in Georgia. He has 4 minor children that he has to pay child support for, and he has been working at landscaping company, but he believes that he lost his jobs ever since September 2nd, 2022. He graduate from high school. He has some trade school education to do the networking engineering. And right now, he does not have income. He has no objection to stay away or no further contact. And we would like to request for signature on bond.
Are any of his children with Miss Leslie?
Just one, Your Honor.
Okay,
Four,
so-
actually. He has 4 children together, 9, 4, 2, and 2-month-old.
Okay, so are you gonna request a third-party transfer
Yes, Your Honor.
for visitation?
Yes.
Okay. So it's gonna be a $5,000 signature bond through the jail, no further contact with Ms. Leslie, stay away from the Jonesboro Road address, no drugs, alcohol, or weapons while out on bond. I'm not gonna keep you away from your children, Mr. Williams, but you're gonna have to have a third-party transfer for visitation of your children, which means that you're gonna have to have somebody intervene since you cannot have any contact whatsoever with Ms. Leslie. So I'm giving you the opportunity to sign yourself out of jail because I want you to either get back to work or get yourself a job so you can take care of these children. But if you violate this bond in any way, you're going to be right back where you are on a $5,000 bond. You understand?
Yes, sir.
All right. Any questions? All right. Good luck to you, Mr. Williams.
That was through the jail, correct, Judge?
Yes, it's through the jail.
Position 9, McMillan.
And this is the case that we need a breakout room in, it's my understanding.
Yes, Your Honor. Myself and Ms. Falk.
Okay. And Ms. Gant and myself.
Yes.
Are we gonna need is this the only breakout room that we're gonna need on this calendar? Okay, I take it that's
No, it is not.
Oh, we have some other ones?
There is another one, yes, Your Honor.
Okay, well, I wanna do them all together since we'll be there. What's the other position? I'm sorry, Ms. Falk.
So it's McMillan, which is position 9, and then there was another PI case that we needed to address as well. That was on the calendar. It's on the add-on calendar, Your Honor.
Okay, who's representing?
That will be mine. And on calendar is
All right.
my client, Your Honor.
All right, so let's put Ms. Kim in the breakout room with us also, so we can address both these at the same time.
Thank you, Your Honor.
Thank you.
I believe if that's Darius White, I need, that's.
Okay, that's your case, Mr. Dudley?
Yes, Your Honor.
Okay, we'll put you in the breakout room also.
Thank you.
Hey, Ma.
All right, good afternoon, Mr. McMillian. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Yes, do you agree to have your case heard by video?
Yes, sir.
Okay, thank you. You have been charged in case 22 CR 006350J with simple assault and another misdemeanor offense. I've had an opportunity to discuss your case in a breakout room with the solicitors and also your counsel. As such, your bond is going to be $1,000 good bond for the simple assault and a $2,500 bond for the second charge, which makes it a total of a $3,500 good bond. No further contact with the alleged victim. Stay away from the incident location, and no drugs, alcohol, or weapons while out on bond. We're also going to have a social worker visit with you and report back to me. If you do not make bond by the time that we have the state all-purpose calendar, which is going to be on October 4th, I'll take a look at your case again at that time. All right. Good luck to you, Mr. McMillian.
All right, thank you.
You're welcome. Can we go? Any questions on this one? If not, I'd like to go to the other one that we had in the breakout room, which is the add-on Darius White. If you all have him there, he's also position 17.
He was actually next.
Oh, okay, great. Thank you.
Yeah.
All right. Good afternoon, Mr. White. I am Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. White, you have been charged in case 22 CR 006361D with battery family violence, simple battery family violence, and cruelty to children in the 3rd degree. You have also been charged in case 22 CR 006356D with another misdemeanor offense. It is my understanding, I've had the opportunity to discuss your case with the solicitors and also with your counsel. I also want to give, if she is on the line, Ms. Hughley, the opportunity to address the court. I don't know if she's on the line or not. Ms. I see you there, Ms. Hughley. If you do not have to address the court, but this is your opportunity to address the court, you'll have to unmute yourself and I'll have to swear you in if you like. Okay, can you raise your right hand for me, ma'am? Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes.
Okay, you can put your hand down. What would you like to tell the court?
Well, he's a good person and he's doing good now. So, but we do have a child together. He's 2, and my oldest son, that Terrence Henderson, the 9-year-old, they bonded together. They doing good. So, I would like to see him out.
All right, so this incident allegedly happened in July of 2022, so a couple of months ago. Have you all been in contact since that time?
Yes, we talk.
Okay, but he does not live there?
No.
And are you all still in a relationship?
No, we co-parents and we have a son together, so.
Okay, are you afraid of him?
No, sir.
Okay, and has had this happened before?
No, sir.
All right, anything else you'd like to tell the court?
No, sir.
Okay, thank you, Ms. Hughley. Mr. Dudley, anything else?
Nothing further from the state.
Ms. Kim, anything further?
Nothing further, Your Honor.
Okay. So for the battery family violence, it's going to be a $2,000 good bond. For the simple battery family violence, it's going to be a $1,000 good bond. For the cruelty to children, it's going to be a $1,000 good bond, which makes for a total of a $4,000 good bond. No further violent contact with Ms. Hughley or the minor child TH III. No drugs, alcohol, or weapons while out on bond. As for the add-on position, and that misdemeanor charge, that's going to be $1,000 good bond, no further contact with the alleged victim, and no drugs, alcohol, or weapons while out on bond. Mr. Dudley, was there a stay away in that add-on case?
Yes, Your Honor.
And where's that from?
That is from 3071 Middleton Road Northwest.
Stay away from the Middleton Road address. All right. Good luck to you, Mr. White. And you also, Ms. Hughley.
Thank you, sir.
Position 15, Timmons.
Good afternoon, Mr. Timmons. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Timmons, you've been charged in case 22 CR 006363F with battery family violence. Is there a history, Mr. Howard?
This is 10th arrest. Last arrest was September 2021. Probation violation. He's on probation for robbery. He had a 2021 arrest for battery DV, giving false name out of Gwinnett. The giving false name was a conviction. I don't see a disposition for the DV. 2019 probation. 2018 probation. 2018 failure to appear. 2017 battery DV conviction. The robbery came from 2016. He was sentenced in 2018 and given 10 years probation for that. Got a misdemeanor theft by receiving conviction, 2015. That's it.
Ms. Falk?
Yes, Your Honor. So I do have some information on that most recent family violence battery. I know pretrial stated there were two, one in 2017, one in 2021. We were able to get in contact with Gwinnett County and get the sentence sheet on that. He was convicted of family violence battery, which is going to cause this case to transfer to the DA's office. So I will be submitting a transfer order to the court today for Your Honor's signature so that it can be transferred, since this would be a qualifying family violence battery previous, which makes this case a felony. That being said, the incident happened August 9th, 2022 at 25 Terminus Place, Atlanta, Georgia. Miss Imani Jones, IMANI Jones, JONES, was assaulted by the father of her child, which is the defendant. Miss Jones stated that they went to see the defendant so he could spend some time with his daughter. However, during that time, they began to argue and she attempted to leave until things cooled down. The defendant grabbed her about her neck, and while she was actually holding their child, and squeezed, resulting in some visible bruising around her neck. She did manage to escape the apartment and end up calling 911. The victim and the defendant are not in a relationship. They don't live together, according to Miss Jones, and they do share one child. Miss Jones stated they are trying to work on co-parenting. She stated that there had been no violence before this incident, but as the court knows, based on the history outlined by pretrial, there has indeed been violence in this defendant's history, even if it was not with Miss Jones directly. She is stating she wants contact, and we are in disagreement with that for obvious reasons based on his history and based on the risk of reoffense. The state is requesting a $10,000 surety bond, and that is based on, again, his violent history, the failure to appear in 2018, the probation violations in 2019, and 2018 and 2019, as well as the convictions for family violence, both in 2021, and I believe there was a previous in 2017, and the fact that he's currently under first offender for robbery in Douglas County from 2018. We are also requesting a no further contact with Miss Imani Jones, stay away from her residence. I do not have that address. I don't believe the 25 Terminus address was the defendant's address and not hers. No alcohol, drugs, and weapons, and third-party visitation with any children. Thank you, Your Honor.
All right, thank you, Ms. Falk. Ms. Kim?
Yes, Your Honor. Mr. Marion Timmons. He is 24 years old, Your Honor, and he has been here in Georgia for about 10 years. And of course, he has a child who is 6 months old. Right now, he has two jobs. One at Mexico border. He's a host there, and also two, he sells a suits. He has two jobs because he wants to make sure that he's providing financially to his family members and his child. And he has high school graduation. Also, he has business trade education from college, but he didn't graduate from college. He has a designing trade school that he's been doing. Also, Your Honor, I guess Mrs. is right there at the iPhone. I'm going to ask her to talk about it in Manny Jones. We would like to have a no further violent contact. Since this incident happened on August 9, 2022, there has been enough cooling time, Your Honor. Thank you.
Okay, that's Ms. Jones there. Ms. Jones, if you would like to address the court, I need for you to raise your right hand. Do you swear affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yeah.
Okay, put your hand down there. What would you like to tell the court?
I would like to have contact with him. This is my daughter's father. So, and he has been coming by. I believe Miss Shelley or somebody called me earlier today. We are trying to work on our relationship and co-parenting and trying to seek out counseling for our family. So I do need to see him for my daughter's sake. Her birthday is coming up. She is about to turn 1. And like I told the lady before, we haven't had any violence like this ever before in our relationship or with my daughter being born. So I request that I do be able to see him and that he gets a bond. And I do not want to press charges any further. I'm sorry. Sorry, my throat was itchy.
Okay, so Ms. Jones, let's see, did you find it necessary to call the police?
In the moment, because I just had so much, I don't want to say animosity or just energy. I was just hot-headed and obviously excited at the time. Excited, but I don't know the correct terminology. My blood rushing, you may say. So at the time it was necessary, but right at the moment and in the past, since we have been talking over about the situation, since he's been coming over here seeing my daughter, it wasn't necessary.
But at the time you found it necessary to call the police.
Yes.
And was your daughter in the household at the time?
She was.
Okay. And okay. Ms. Falk, anything further?
Nothing further for the state, Your Honor.
Okay. Anything further, Ms. Jones?
No, ma'am. No, sir.
Okay. So it's going to be based on the history and based on what I've heard, a $10,000 good bond. At this point in time, no further contact with Ms. Jones until the situation gets resolved. Stay away from the address. I'm not going to keep you from seeing your child, Mr. Timmons, but you're going to have to do that through a third-party transfer of the child. And let me tell you,
Your Honor, 25 Terminus place is actually his place, and Miss Jones does not reside there. So can we have a clarification about that?
Yes, stay away from Miss Jones's Miss Jones's place. Yes, Miss Jones.
We do not have any, we're both young, so we don't have anybody to go through a third party. So I would need him to come see his child. He has no problem with being around me. He was just around me before he got locked up. So, and I'm not fearful of my life with him coming to see my daughter. Like I was telling the lady before, he comes and takes her out. We go on little places and stuff, but right now at the moment, he wouldn't have a third party to be able to come see her, if that's understandable.
No, it's well, he's gonna have to find one because I understand what you're asking of me, but until this is worked out, he's to have no contact. And like I said, I'm not gonna keep him from his child, but he can have no contact with you. And let me just make that clear to you both, and also especially to you, Ms. Jones. You will not be doing him any favors if you allow him around, because if it gets back to this court through any way that he is having contact, then this bond is going to be immediately revoked, and he's going to be right back where he is. No contact means no contact whatsoever. No contact via phone. Obviously no contact personally. No contact. No contact by social media. No contact whatsoever. I'm particularly concerned about your child. You know, you can say that yes, and again, the moment of heat, I did call them, but no one wants to expose a 2-year-old child to any of this type of, nonsense, okay? And you should be most concerned about your child in that regard. So until this is resolved, no contact whatsoever, but I'm not gonna keep him from his daughter, but he will have to have a third party conduct that.
Okay, so can I ask you a question, sir? She has a birthday coming up. I'm pretty sure that you guys are not gonna resolve this by that time. So how is that supposed to be played out? Because he's actually participating, he's paying money towards her birthday. So
well, I'm not stopping him from doing that, and he can celebrate her birthday with her at another time. He can at another time of the day, but he just can't be around you. Okay. So I'm not keeping him from his child. I'm not keeping him from celebrating with his child. You all are just gonna have to work it out, okay? So, and again, like I'm saying, it's not gonna do you any good if you're the one who allows him to come over, because he'll be the one that's sitting back in jail, okay? And no drugs or alcohol or weapons while out on bond.
Yes, sir. Thank you, Mr. Moore.
Okay. All right. Good luck to you.
Thank you.
All right. Who do we have next?
Position 12, Rainwater.
Good afternoon, Mr. Rainwater. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. Mr. Rainwater, you've been charged in case 22 CR 006351A with public drunk and 3 counts of obstruction of a law enforcement officer. Is there a history, Mr. Howard?
Tell me when to stop. 56 total. Last arrest was in July, probation violation. Another July arrest as well for shoplifting, misdemeanor obstruction, simple battery. February, failure to appear for the following: 2 count shoplifting, 1 count misdemeanor possession of marijuana, possession of cocaine. February arrest for obstruction. 2020 probation felony. It's for the cocaine from 2019. I got failure to appears from 2019 for DUI, DUI drugs, obstruction, driving without a valid license. Another DUI drugs. 2016 probation. Another 2016 probation.
Okay, thank you, Mr. Howard. I think I've got it. Mr. Dudley?
Yes, Your Honor. This incident took place yesterday, September 19th of 2022, at 2420 Piedmont Road Northeast. The defendant was heard by MARTA officers saying to someone over the phone in an utterance that I'm drunk, and they saw him drinking from an open margarita beer container at the Lindbergh MARTA station. The officers approached the defendant and notified him of his violation. The defendant was asked to show his ID and he refused, walking away from the officers saying that he doesn't give a shit. Officers then attempted to detain the defendant by placing him on the ground and ordered him to put his hands behind his back. The defendant resisted by not putting his hands behind his back and continuing to use his cell phone. Officers were eventually able to get the defendant's hands behind his back and in the handcuffs, and they told him at that point to stand up so that he can be taken to the police precinct. The defendant told the officers he was not getting up and that they would have to drag him. He told the officers that he was too drunk to move, but attempted to crawl towards an oncoming train. The officers attempted The officers held the defendant in place so that he would not harm himself and had to carry the defendant by his arms and legs to a MARTA vehicle to be taken to the police precinct. Given the FTAs and probation violations mentioned by pretrial, the state has concerns that the defendant is a potential flight risk, and the state is going to recommend a total $2,250 surety bond with the breakdown of $250 for the public drunkenness and $500 for each count of obstruction. Stay away from the incident location, and no alcohol, drugs, or weapons while out on bond. Nothing further from the state.
Thank you, Ms. Kim.
Yes, Your Honor, Mr. Dalen Rainwater is 44 years old and he was born and raised here in Georgia. He has 3 minor children, Your Honor, 14, 12, 11, and he is currently financially providing for them. He's currently married and he has job at Trist Park. He's been working there for about 3 years and he does not want to lose his job. He graduated from high school and he has asthma, and right now he cannot breathe well because there's no inhaler, and he ordered it, but it's gonna take about a couple weeks to get the inhaler, so he really needs to get out of the jail so he can breathe better. He has been at Sober Living America for the last 9 months, and we would like him to continue his rehabilitation there. Signature bond would be the best. However, if Your Honor is not inclined to give him a signature bond, please give him maximum $1,250 good bond. Thank you.
Okay, so it's gonna be a $250 good bond on each charge, which makes it a $1,250 good bond. Stay away from the Lindbergh MARTA station on Piedmont Road. And no drugs, alcohol, or weapons while out on bond.
Your Honor, can he use a train for work only? Stay away from Lindbergh MARTA, except when he has to go to work.
Does he need to get on at the Lindbergh MARTA station?
Yes.
Okay, so I'm going to have him abide by any MARTA suspensions.
Thank you, Your Honor.
All right. All right, good luck to you, Mr. Rainwater.
Position 5, Ibrahim.
Good afternoon, Mr. Abraham. I'm Judge Eric Morrow. This is the State Court Expedited Accusation calendar that we are conducting by video to help prevent the spread of the virus. Do you agree to have your case heard by video?
Yes, sir.
Thank you. You have been charged in case 22 CR 006346J with theft by deception. Is there a history, Mr. Howard?
First.
Ms. Duncan?
Yes, Your Honor, this incident did occur back on November 25th of 2021. It occurred across several social media and social payment platforms. In this incident, the defendant is accused of having deceived the victim in this case, Stacy Jones. Stacy is S-T-A-C-I-E. Jones is common spelling, out of $225. She was communicating with someone on Facebook about purchasing a Shih Tzu puppy. And when she was asked, she was given the contact information for a Venmo to pay for the puppy. And that Venmo account did trace back to the defendant in this case. Officers were able to subpoena those records upon further investigation. She paid $225 for the puppy as a deposit. And when it came time to retrieve the puppy and receive the puppy, all contact between her and the person who was selling the puppy ceased. She never received the dog or any of her money back after several attempts. And just as far as identification purposes go, officers subpoenaed that Venmo that the money was sent to, and all of the returns from that subpoena did eventually lead back to this defendant. Given the defendant's lack of criminal history, the state is going to be requesting a $3,000 signature bond through pretrial. Contact only with the victim to return the $225 paid for the dog. No alcohol, drugs, and weapons, and no further violations of Georgia law. Nothing further from the state.
Gant.
Thank you, Your Honor. Mr. Kyoto Ibrahim is 30 years old. He has been in the Atlanta, Georgia area for 3 years. He has family here, including an uncle and a cousin. Your Honor, Mr. Ibrahim completed high school. He also has a degree in sociology. He is currently employed at Lowe's and has been so for the past 2 years. He denies the allegations. We are unopposed to the state's signature bond. We are also unopposed to no contact. My client does not know Ms. Jones. We are opposed to any orders for no contact in terms of paying, returning money. My client is presumed innocent, Your Honor, and restitution has not been ordered by a court. Therefore, I am opposed to that condition, Your Honor. Thank you.
All right, a $3,000 signature bond through pretrial, no further contact with Ms. Jones, no drugs, alcohol, or weapons while out on bond. Good luck to you, Mr. Ibrahim.
Thank you.
Thank you, Your Honor.
Position 7, Lockhart.
Okay, so I've been informed that position 7 and position 3 are related cases. So if we can take
Bonded out.
Who bonded out?
13.
That is correct, Your Honor.
Okay. So it was 13 and 7.
And also there's
It's
a no
3 and
cross
7,
in
Your Honor.
13.
Okay, I have a null cross for position 13.
Yes, I do too.
That's
And-
correct.
And tell me again, this is Mr. Lockhart. Was
Right.
there?
His counterpoint is position 3, Cedrine Bird.
Okay, and who bonded out?
Benson. So there was a co-defendant. There's actually 3 defendants. Tanya Benson was the third. Tanya Benson bonded out.
Okay, thank you. So what I was trying to get courtroom 2 was, do we have Cedrine Bird in courtroom 2?
Stand right next to him.
No. Oh, okay. So as long as that they can hear, since these are the same cases. Okay, thank you. And who's representing Mr. Lockhart?
I am, Your Honor, and also, I represent them both. Yes, Ms. Bird
Okay,
as well.
all right. So good afternoon, Mr. Lockhart and Ms. Bird. I'm Judge Eric Morrow. This is the State Court Expedited Accusation Calendar that we're conducting by video to help prevent the spread of the virus. Do you all agree to have your cases heard by video?
Yes.
Okay, so Mr. Lockhart, you've been charged in case 22 CR 006359C with battery, and Ms. Bird, you've been charged in case 22 CR 006358Y with battery. Mr. Howard, Mr. Lockhart's history.
First for both.
Okay, first for both. Ms. Falk.
Yes, Your Honor. So this all happened September 19th, 2022 at Captain D's at 1095 Ralph David Abernathy Boulevard in Atlanta. The defendant who bonded out essentially spoke to police, stated she had a dispute with Mr. William Treadway. Mr. Treadway was then interviewed by police. He stated he requested a refund from the store employees because they were out of a product, and the store employees became rude with him, so he began recording them. The officer was able to get the recording from Mr. Treadway. So everything else that I'm about to tell you is based on the officer's viewing of the recording. The recording shows that Mr. Treadway was in front of the counter. Benson, the bonded out co-defendant, was behind the counter. Benson then slapped Treadway's phone out of his hand. He picked it up, went into the parking lot, was calling the employees' names, calling them names, in other words, just yelling, just generally. He's outside, they're inside. They decide to come outside. Benson, the bonded out co-defendant, with a pole in her hand. She then goes back inside. Lockhart comes out, approaches Treadway, questions whether he assaulted Benson, which Treadway denies. And there's nothing in the video that shows that Treadway ever touched the defendant, the co-defendant Benson. Defendant Bird then comes out, approaches Mr. Treadway and swings at him, which causes him to fall to the ground. At that point, his phone goes out of his hand and an unknown citizen picks up the phone, continues recording, at which point the officer is able to see all three defendants, Benson, Bird, and Lockhart, kicking Mr. Treadway. Mr. Treadway suffered multiple scrapes and cuts on his knees and elbows that the officers could see, a busted, swollen lip, a swollen nose, a swollen left eye, and he had several dreadlocks missing. He did transport himself to Grady, and we did follow up with him. He stated that he is currently at the hospital waiting to be seen by a doctor. He stated that he has a swollen leg and a split lip. He will need, he believes he will need x-ray on his legs to see if anything is broken. He also stated that he may need stitches to his lip. So I just want to point out for the court that if anything of that is correct, if his leg does turn out to be broken, or if he does require stitches, we will be moving to transfer this to the DA's office as an aggravated assault. However, he will keep us updated, and he is here on the Zoom. Miss Benson already posted a $2,500 surety bond. We're saying what's good for the goose is good for the gander. We're asking for the same $2,500 surety bond, which is currently set on both of the other defendants, to remain. Although they don't have a prior history, this was essentially just a group of people coming out and beating a man severely for what amounts to asking for a refund. I mean, this is just honestly ridiculous. And so we are asking for that $2,500 surety bond, stay away from Captain D's unless they are still employed there. And we are asking for no further contact with Mr. William Treadway, and that is Treadway. And furthermore, we're asking for no alcohol, drugs, or weapons in one-day anger awareness. Thank you.
Ms. McLeod?
Yes, Your Honor. My client, Mr. Bird, is 19 years old, and Mr. Lockhart is 21 years old. As been noted, neither of them have a record. And I hear the story about these people randomly attacking a customer. And I am sure the court understands that is highly unlikely that is what took place. As a matter of fact, my clients tell me that Mr. Treadway, this is not the first time he has come to that particular location. When he comes there, he's always inappropriate in his behavior. He calls them names, and in this particular instance, he attacked one of the female managers. Mr. Lockhart told me that when he saw her fall on the ground, this was when he heard a commotion. He was inside in the back working, it's not out front. He heard a commotion and he saw his manager on the ground, a female, an older female, unable to get up. And was when he ran out there and got involved with this. This wasn't a situation where they just decided to beat up on a customer simply for asking for a refund. That is not at all what happened, Your Honor. Mr. Treadway went in there, he misbehaved, he acted up, and he attacked a female manager. And Miss Bird and Mr. Lockhart were just trying to help this older lady, and this is really what happened. It's not that they attacked the customer. They have been working there for some time. And if they were in the business of just randomly attacking customers, they would still not be employed there. The fact that neither of them has a record speaks for itself, Your Honor, and I would ask the court in this instance to give these two young men signature bonds so they can get out of jail and continue to work and get on with their lives. Both of them have no children. They're working. Both of them have told me that they live with their parents. So I don't think they're a threat to anybody.
Do we know who called the police, Ms. McLeod?
Another co-worker called the police, Your Honor, and this other co-worker called the police because
Ms. Benson, the co-defendant, let's be clear about who called the police. One of the co-defendants who kicked him called the police. So it wasn't just a random co-worker who had no dog in this fight. It was one of the co-defendants who bonded out on a $2,500 surety bond.
But the fact that she called the police is an indication that she saw that something was happening, that it was appropriate to call the police for help. She had someone there who was just not acting right.
And again, I would reiterate, all this was captured on video and observed by the officer.
Yes, but that was a video that he was taking. We don't know what the other perspective would have seen.
Mr. Treadway, I see you there. If you would like to address the court, I need for you to raise your right hand for me, if you can. Do you swear or affirm the testimony you're about to give before this court be the truth, the whole truth, and nothing but the truth?
Yes, sir.
Okay, you can put your hand down, Mr. Treadway. Tell me where are you?
I'm here at Grady.
Okay.
Grady Hospital.
All right, thank you, sir. What would you like to tell the court?
Well, first and foremost, I'd like to say that I heard that they mentioned that I attacked or did something to this woman. I'm sure the footage in Captain D's, not just my footage, but the footage in Captain D's will show that that's not the case. The other point I wanted to make was that she did fall, right? But it wasn't because of me. She was so adamant about trying to hit me that she lost her balance and fell. She came outside. I had already left the place of business. I came outside. She followed me outside and swung a stick and tried to hit me and lost her own balance and fell. And then what makes it more interesting is that when these gentlemen said they came out to see what was going on, all this was all happening at once. So when they came out, and I addressed it and said, hey, I'm recording everything and I never touched that woman, they all go back inside as if it's over and then come back out again. So it's like they had two different it was like basically they went inside, and then when I was about to go over and get my bike and leave, because my bike was still kind of leaning up against the window, like my bike was still leaning up against the building. So I couldn't even go get my bike because before I could even go get my bike to leave, they came back outside again. And I'm like way across the parking lot. So they came way across the parking lot to continue, assaulting me. So I'm just thinking like, wow, like, so not once, but twice. Like she came out, hit me with the stick. That whole thing happened. She lost her balance. Then they all went back inside. Then they came back out again. So it was two different situations. Like they still didn't let it go. They weren't gonna let me leave there unscathed.
All right, thank you, Mr. Treadway. Why do you think this was happening?
To be honest, sir, once you see the video, she looked like she was high or something. I don't know, man. I don't know if it's drugs. I don't know what was going on. I don't know these people from a can of paint. I lived in the neighborhood I went to college over here. I went to Morris Brown. I've been living in this area for years. I've never seen them outside of that restaurant. I've never seen them at the grocery store. I've never seen them in the community. So I don't know where they live, but I've never seen them. So basically, I'm just basically trying to say that there's nothing for her to be for any of them to be as upset as they were about giving me a refund. There's no there's nothing that they can stand on to say that, hey, I don't know them, their family, anything. I've never done anything to them, but they have like a personal vendetta. And my whole thing is the only thing they can have an issue with me is that I'm a person that when I spend my money, I have a right to, if something's not correct, to send it back to get a refund. So yes, like maybe like, what was this? I mean, this was literally over a year ago. This was like when the pandemic first started. When the pandemic first started, I came by the store and there was a situation similar, like, back when she was kind of being a little ratchet with me then, but I let it go, because it got settled. But my point is that ever since then, because I have a unique look, I have a lazy eye. I'm a person that when I come by, it's me, I mean, I got locks. So I have a very unique look. So long story short, I've been there several times since then. I mean, if you look on my account, I've been to this store at least 40, 50 times in the 5 years that I've been moving back into this neighborhood. So, but out of those times, I might have like had to send back my food maybe 3 times. And this particular woman or whatever, took a personal issue with that, like as if she owns Captain D's or something, like as if I'm taking money out her personal pocket or something. And so now when I come in there, when she sees me, it's like literally as soon as I walk in the door, it's like, oh, here he goes again. Here he goes. You ain't gonna be here causing trouble again today. Or like, and at first I just thought it was a joke. I laugh it off, whatever. Because like I said, I still go back. So I didn't think it was that serious. But yesterday, I didn't even know this woman was there. she was like all the way in the back. So I never even knew she was present. Everything went smooth. I put in my order, but it did take exceptionally long for my food to come out. So I'm being patient. But I mean, it's a fast food place. So it's like 20, 30 minutes goes by. So now I'm kind of like wondering like, okay, where's my food at? And then some confusion happens. And then they finally bring my food out. Not only is it cold, but then I don't know if you've ever been to Captain D's, but I'm a real fan of their bread. So I asked, it's only natural to ask for butter with my bread. So the one guy who's there now with the locks, he was the one who was serving me or whatever, and he had an attitude. Like first he said he puts the food on the counter. And he goes, so what else do you want? And I'm like, I ordered mozzarella sticks. So doesn't marinara sauce come with that? So he hits me with the, no, it doesn't come with it. But I mean, if you want it, you got to ask for it. And so I'm like, what? I'm like, that's what you sell it with. You sell mozzarella sticks with marinara sauce. Like, he actually made that a thing. So I brushed it off. Because I felt the attitude. I brushed it off. And then with the bread, I said, sir, could I at least get some butter? Then he goes, there's no more butter. So I'm thinking he's joking because he's kind of smirking when he says it. So then I go, I ask again, I say, sir, I just want some butter so I can go on about my business. He screams to the back, hey, this guy don't believe me. I told him there's no butter in the building. So he starts making a whole spectacle of it or whatever. So it's for me to go ahead and just shut it all down. I said, you know what? Just go ahead and give my money back because I'm not even going to enjoy this meal. I don't want to eat no bread with no butter. You didn't tell me that when I first put in my order. And this whole time I've been out here waiting, I didn't hear you mention that once to the customers to say, hey, excuse me, I just want to let everybody know we're out of butter, because I probably wouldn't have ordered it if I'd known that. And, so next thing you know, that's when she appears. She comes from out the back. I didn't even know she was back there the whole time. And then she comes out and she goes, oh, him again. No, he ain't getting no refund. I ain't giving him nothing. And then just starts going off like, yeah. And then like really being bold with it, saying that, and I'm Miss Tanya. You can tell him I said it. And So it got so ridiculous, sir, that I had to pull it's so much that I didn't catch on video. Like it got so ridiculous that I had to pull out my phone just to kind of calm things down, you know what I mean? Because I was thinking that once I pulled my phone out, that they were gonna have some sense and say, you know what, let's just get this man his money and get him out of here. You know what I mean? Let me be professional. But when I turned the camera on, it was like as if they didn't even care about their job. They didn't even care about that I was recording. It was like, it just made them want to act a fool even more, which was kind of ridiculous to me. I'm like, these are grown people. I'm recording you. I'm even making sarcastic comments saying, hey, Miss Tanya, so you don't care. You don't even care about your job, do you? And she's just still going off. And not only going off, comes around the counter, approaches me, smacks my phone, then threatens me, picks up a fire extinguisher to hit me with the fire extinguisher. Her own coworkers couldn't even hold her back. I'm telling you, like this lady, and she's kind of, I don't know if you've seen her, but she's got a little size on her. She's kind of, she's big like Medea or something, you know what I'm saying? And literally her own coworkers, men were in there. They could not hold her back. How did this woman make her way outside? I left the building. She made her way outside with a stick and still had time to strike me. So I just had enough time to put up my right arm and block it. And when I blocked it, she was trying to go for another swing. And she lost her own balance trying to hit me. And then they're looking at me as if, oh, you hit a woman. I'm like, I never even touched that woman.
Okay,
But like I said,
Mr. Treadway,
yeah.
Thank you. I think you've come full circle now. I think I've gotten the whole
Yes, sir.
picture.
Yes, sir.
Thank you. I appreciate that.
Lorna, may I say something?
Of course, Ms. McLeod. And I know that one of your clients is trying to get your attention. I don't know if he has something that would be
Your Honor, I prefer if they do not speak, but I will say in all of his narrative, it seems to me that what he's saying is that someone else who's not presently before the court was really the aggressor, and he has not said anything which goes against what I have asserted, that my clients were merely trying to protect a woman who they thought was under attack.
And as
And
Your
neither
Honor
of
is
them
well aware
have
of,
ever been arrested, Your Honor.
and as Your Honor is well aware, self-defense does not apply after the incident. You don't get to then use the incident itself a couple of minutes later or a minute later to then attack a person. After the danger
attack
has
anyone.
passed.
He only speaks about being attacked by someone who's not here.
Okay, so neither of these young men have a record. I'm gonna send them, I wanna monitor them, so I'm gonna send them through pretrial. It's gonna be a $5,000 SOB through pretrial for both 1-day anger awareness for both, no further contact with Mr. Treadway for both, no drugs, alcohol, weapons while out on bond. As far as the stay away from Captain D's, if Captain D's did not fire them, then then they still have a job and they can go back there. But given that there's no further contact with Mr. Treadway, if Mr. Treadway decides that he wants to go back to Captain D's, which I don't understand why he would, then they necessarily won't be able to wait on him or be around him. Okay. Good luck to all of you all.
Thank you, Honor. Listen, Mr. Bird, Mr. Lovecraft, you can call me later and we can talk about your cases, okay?
Okay. Yeah. Where would I be able to contact you?
Don't say anything. You can talk to me.
Yes, how much?
It's
5,000 signature, I believe, Your Honor. I think
Yes, 5,000 SOB through pretrial, 1-day anger awareness for each. Okay. Good. I hope you men well, Mr. Treadway. Have a nice afternoon.
All right, thank you.
You're welcome.
Your Honor, that concludes my business before the court today. May I be excused?
Yes, Ms. McLeod, always good to see you.
Good to see you too, Judge. Thank you.
Who do we have next?
I have a quick announcement for position 1. It's going to be a medical reset.
Okay,
And
until tomorrow.
yes.
So that's at 9/21. Okay.
Also, position 11, they waived their appearance. And we're completed here in courtroom 2, Judge.
Okay, do we have a written waiver?
Your Honor, I will work on it and then submit it shortly, Your Honor.
Your Honor.
Yes.
I do apologize for interrupting. I do have an appointment at 4 p.m. May I be excused?
Yes, Ms. Gann. Have a good afternoon. Okay, thank
you, Your Honor.
You're welcome. Thank you.
All right.
Courtroom 2. I think we've taken care of everyone, and we will handle the waiver case now.
All right. Thank you, Judge.
All right. See you next time. Thank you. So this is position 11, Kimberly Fees, charged with theft of service. Is there a history, Mr. Howard?
It's a 4th arrest. Last was 2006 DUI. Hold on, 1, 2. This is a 3rd arrest, I'm sorry. Clarify that. But that's it. Last arrest was 2006 DUI. Before that was in the 80s.
Okay. Mr. Dudley?
Yes, Your Honor, this incident took place yesterday at North River Tavern, located at 8879 Roswell Road, where the defendant ordered food and drinks in the amount of $167.08. When it was time to pay the bill, the defendant refused to give any credit card to the bar staff to close out her tab. The defendant said that she uses Google Pay to pay for her items, and so the staff allowed her some time to access her Google Pay account, but she did not access it and instead gave the bar staff 2 Chime credit cards that did not work due to insufficient funds. The defendant was given more time to access her Google Pay account, but again was unable to, and ultimately unable to pay for the things that she ordered, and was charged with theft of service. The state is going to recommend a $2,000 signature bond through pretrial services, a stay away from the incident location, and no drugs, alcohol, weapons while out on bond. Nothing further from the state.
Okay, it's going to be $1,000 signature bond through the jail, stay away from the North River Tavern, and no drugs, alcohol, or weapons while out on bond. Does that suit you, Ms. Kim?
Yes, Your Honor. Thank you.
Okay. I see you there. I'm not sure. I see Bryant. Is it Pless? Are you related to?
That's her husband, Your Honor.
Right. I just want to acknowledge him that I see him there, and that if he wants to, he needs the court's attention. Apparently not. Okay, I think that concludes today's calendar. Is that right?
Yes.
Yes, I believe so, Your Honor. We just asked that, and we normally don't do this. We normally would have objected, but I just asked that PD Kim go ahead and file that by the end of the day so that we have the waiver on record.
Yes.
Right. And that's why I let her. Mr. Pless, you need to unmute yourself so I can hear you if you'd like to speak to the
Very
court.
good. Yeah, I just, I don't know if Kimberly can hear me or not, but I did want to just share.
She is not with us for some reason, sir, and I gave her a signature bond. Okay.
Okay,
So
I heard everything. I appreciate it. I just have one quick thing to ask, and really this has nothing to do with I guess this certain case, but my wife just got out of Peachford Hospital not even a week ago. This is probably going to be something that we will struggle with a little bit. Thank you for a little bit of time, and we cannot get
Your Honor,
I'm sorry.
Okay.
Can I? What I'm looking for, I guess, is just some guidance as to how I can try to
please
keep
call
this.
me so that I can explain to you, Mr. Brian, please.
Please, okay.
Yes.
Okay, so Ms. Kim will give Ms. Kim, can you give him your number in the chat? And
Actually, I know his number. I can call him.
Okay.
I appreciate that. Yeah, I appreciate any
Okay.
kind of help that I can get. Would be,
Okay, so
would be more than.
Yes.
She'll give you a call. Okay.
I appreciate that. Thank you very much.
You're welcome.
Thank you.
Good luck to you, sir.
Thank you.
Anything else before we go over the calendar?
Nothing further, Your Honor.
Okay.
Okay,
Ms.
if we're
Bridgewater?
ready. Yes, sir. Once again, the reset date for the SAP calendar is going to be October the 4th. Position number 1 is a medical reset scheduled for tomorrow. Position number 2 is a $2,000 SOB through pretrial per judge and will be reset further notice. Position 3 is reset further notice with a $5,000 SOB through pretrial. Position 4, oops, I don't have that one written down. I'll come back to that one. But at any rate,
3,000 pre-trial, right?
Yes.
okay, and again, it will be reset further notice. Position 5, reset further notice with a $3,000 SOB through pretrial. Position 6 is reset further notice with a $5,000 SOB through the jail. Position 7 is reset further notice with a $5,000 SOB through pretrial. Position 8, reset further notice with a $5,000 SOB through pretrial. Position 9 is going to the SAP calendar with a $3,500 total good bond. Position 10 is reset further notice with a $2,000 total SOB through pretrial. Position 11 is reset further notice with a $1,000 SOB through the jail. Position 12 is going to the SAP calendar with a $1,250 total good bond. Position 13 has been null pros. Position 14 is reset further notice with a $3,000 SOB through pretrial. Position 15 is going to the SAP calendar with a $10,000 total good bond. Position 16 is going to the SAP calendar with a $1,000 good bond. Position 17 is going to the SAP calendar with a $4,000 total good bond. Position 18 is reset further notice with a $5,000 SOB through the jail. And the add-on is reset to the SAP calendar with a $1,000 good bond. Are there any questions, comments, or otherwise? Okay.
Did you get my waiver?
No.
Huh?
I sent you 10 minutes.
Mr. Howard asked if I would be here tomorrow, and I
No. I said, did you get my waiver?
I did, and I responded to you in the chat. Didn't I?
And Ms. Bridgewater confirmed she did get the order